proceed. This public meeting is held in compliance with the Freedom of Information Act, and notice was posted in accordance with the call meeting procedures. Local media sources were timely notified as well. I won't go through the introduction of the members again. We've done that before, and they all have their names displayed on the placard in front of them. We have asked for participation at this meeting, and we encourage those of you here or anybody watching on television, if you can get here in time, come on and tell us what you know or what you would like. We have some speakers who have already signed up. That's Warren Harley of the Municipal Association of South Carolina, Scott Price of the South Carolina School Boards Association, Jared Bruder, South Carolina Law Enforcement Officers Association, and Gardner Gore, a public citizen. Is the sign-up sheet still in the room somewhere?
It is in the back corner, yes, sir.
Well, don't be shy. As you know, we are meeting here pursuant to the executive order issued by Governor Haley to study ethics reform, and we will proceed tonight with our first speaker, Mr. Warren Harley, provided do any of the commissioners have something to say before we begin? Okay. And also Professor John Simpkins is here. He's our legal expert. I hope we have some legal expertise on the commission besides that, but we're delighted to have him. First witness is
James Burns.
James Burns. James Burns is the legal counsel. You all know him. All right. Mr. Warren Harley of the Municipal Association of South Carolina.
Good evening,
Good evening.
General Medlock and General McMaster, other members of the commission. Thank you for this opportunity to speak to you on behalf of the Municipal Association. First of all, I'd like to say that we certainly support what you're trying to do and actually believe that the idea of moving forward with focusing on how to improve openness in our meetings, in our day-to-day operations is very important to us. Excuse me. Having said that, I do also want to point out some of the things that the Municipal Association already does to encourage our membership and to also train our membership on what they need to know with regards to open meetings, regards to the full implementation of the Freedom of Information Act. The association often every year partners with the South Carolina Press Association with Mr. Bill Rogers to do training through our Municipal Elected Officials Institute. We provide training on the FOIA Act to make certain that they know on a daily basis what they have to do in order to comply with that. We also have a monthly newsletter that we put occasional stories in that help them as far as reminders of what they need to do. Mr. Rogers also, again, has an article that is coming forward in the next few months that will be in our Uptown newsletter. So we hope that our comments will be taken in view of what we already do to try to make sure that our members are up to date on what their responsibilities are. Having said that, I do want to point out some of the challenges as we see them in dealing with being compliance with FOIA. First of all, some of our members have pointed out that meeting the FOIA requirements can be demanding on the time and the staff resources, as well as the ability to run the day-to-day operations, because we have so many small communities, and the amount of requests sometimes takes away from what they're required to do on a daily basis. And so some of our cities and towns also point out that FOIA has been used to augment or some way, I guess augment would be the right word, to augment the discovery process by attorneys. And so instead of using FOIA, they use, instead of using the discovery process, they use FOIA, again, making a broad request, requesting information that sometimes bogs us down. We also hear that the involvement of it requires the involvement often of multiple employees to fulfill some request. We also want to point out that it's very cumbersome sometimes when we have a request for information that dates back for a number of years. Because of our record-keeping process, some cities are not have not kept all of their records electronically, and so they have a struggle going back to storage facilities that may be off-site and somehow trying to pull the information together. It takes more time and more effort. Again, this is not something that we resist doing, but we just want to have that understood when we as we move forward, anything that you might try to do to address it. Our challenge is to ensure that the records request is properly fulfilled. Also, we want to make sure that we release information that is appropriate and not information that should be kept private. And so if there's a request for every email that a city administrator has sent to a particular council member or all the council members or staff members, that particular city has to go through to make sure that they are not releasing information that should be kept private, personal information of some sort. So whether it's account information that should be redacted and before they're released, all those things have to be considered. So we go through that information to make sure we're releasing the appropriate information and releasing information that fulfills the request. We've thought through this, and we have several areas that we think you should consider, or several areas that we would encourage you to look at as you go down this road. First, we think you should look at solutions to deal with cost and the definition of those costs. Entities need to be able to collect for the actual costs, and that's the wording that's used in the law now. But we want to make sure if you do any changes that you can do if you can do anything to clarify what actual cost is, that would be helpful. It is also important that we maintain the ability to be able to charge for the time and materials that we're putting into providing or fulfilling the request that's been put forth. We've had stories of people asking for a tremendous amount of information and then not coming to pick the information up. So the city has gone through the effort and time to fulfill the request and then at the end of the day not having that information being accepted by the person making the request. Also, we suggest that you look at response times. If you do anything with response time, we want to make sure that you keep in mind that the complexity of the request should be considered. We also encourage you to consider the age of the record. As I mentioned earlier, there are records that, for some reason or another, that haven't been kept or scanned electronically, and so the municipality has to do some extra searching or some extra work to get to those records. And we want to make sure that that's considered in any time that you put forward. The form of the record should also be kept in mind. Again, we mentioned whether it's stored electronically or not. And finally, we do have a suggestion. We think that you should look at the enforcement mechanism. We believe that it should be an easier process to deal with resolve disputes with regards to the Freedom of Information Act. When there is a disagreement on what information should be released, we think that some mechanism should be put in place that's a lot easier than the current process and going through the courts. Ultimately, that could end up being where we go, but to start, there could be some use of either the Attorney General's office, some form or function of FOIA resolution could be put in the Ethics Commission or some method to go through the administrative law courts. We've heard some of those suggestions before. I'm not going to sit and tell you that we have a particular preference at this time, but we would be willing to talk with you and work with you on getting to a better place than we are right at this point. That concludes what I have to say. I would be happy to take any questions you might have at this point.
Thank you, Mr. Harley. We may have some. Any members of the commission would like to ask the gentleman a question? Dean?
If I might, are there any studies, you talked about collecting actual cost, are there any studies you're aware of that try to come up with what is a relevant and reasonable cost for FOI searches?
Not aware of any studies. I know that we can look at some other states. I don't know, you may have already done that, but to figure out what's being done currently, that's something that we can work towards.
And when you talk about the burden on, particularly on small communities, how prevalent are these requests? Are we talking about a couple a year or a greater frequency than that?
It depends on the community, I guess, and what's going on at a particular time. I wouldn't have a way of, much of this is anecdotal, wouldn't have a quantifiable number at this point. It's something that we've heard as we talk about what you're doing and what you're looking forward to work on. Those are the concerns that have come up through our people, that there are times when I hesitate because to say nuisance requests, but there are times when I know our folks have been burdened with requests that are not necessarily aimed at getting the information per se. We have no problems with the reporter request because they're generally specific about what they want, and they're trying to do a certain task, and so it's clear on what they want.
Thank you.
I have a quick question.
Starks?
Let me ask you this, with your, I guess with the smaller municipalities, are they still using paper, or they're using electronic storage now?
Some are, I wouldn't be able to speak to exactly how many are using what, but I will tell you that there are a number of our smaller municipalities that would not necessarily have the electronic storage capacity or capability to do what, say, a larger city or what the state does. And so that is something that we would need to consider. Some of them are 5 or 10 people operations. And so we have to keep in mind that when you tie up the time of 1 or 2 people, it's a significant burden on that community. Again, want to make it clear that our folks are in no way saying that they don't want to comply. They just know that there are times when it can be burdensome.
They don't have a choice as to whether they can comply.
Certainly.
None of us do. Any more questions? Yes, sir. Mr. Haygood?
Follow-up question, Mr. Harley. You suggested situations where some may have made requests and it may have been requests for requiring significant effort, and then documents may not even be picked up. Am I not mistaken that there is actually there's a process, an ability to request reimbursement up front, or to identify the size of the effort required and request payment up front before undertaking that kind of effort?
That is correct. There's a process where the city can ask for a deposit. Some cities don't do that. They, in good faith,
Sure.
Complete the request and go forward. But you're correct.
Yeah, I can certainly see how there can be situations where, for whatever reason, somebody might try to abuse that, abuse those rights, and it could certainly be burdensome. But I'm wondering if the answer is perhaps better administration under the tools that are there now, or whether it really would require some sort of legislative or regulatory change.
Right. I will say, I heard some of the remarks Mr. Bender made last time before you, and I would agree with him in that the current law is a good law. Just that if there are any tweaks, those are some things that we believe you ought to keep in mind. And knowing what was introduced last year, just to bring it full circle, there was some concerns from our standpoint about the time restraint, the time of response, the cost, the allowable cost that we could recoup. All those things were concerns that we had based on last year's legislation. And I know you guys are looking at doing something new, but just as a reminder, we want to keep that in the forefront.
Thank you.
Mr. Harley, one of the issues that has been raised is the difficulty in having resolution of disagreements or conflicts. And I think the way it works now is if the requester and the requestee don't agree either on the cost or the scope or any of that stuff, they have to go to the circuit court.
Correct.
Which of course, is a local court. The circuit court meets in every county, so you might not meet there that month, but it'll meet there. But would it be just as good or better to have that moved to the administrative law courts, which are in this building, or to an ethics commission if the one is given the power to do that, which right now would all be in Columbia? What do you think?
We believe that those are good options to investigate without saying which one we prefer at this point. We certainly believe that the process should be a lot simpler than it is at this point in time. Remind everyone that when we go to court, taxpayers pay, and so anything that we can do to keep those costs down would be preferable to us as well.
Some people have suggested an informal proceeding not requiring attorneys before the administrative law courts. Some have suggested. I want to Solicitor Jackson, you ran the show over there in your circuit for many years. Can you give us an idea of what the backlog of cases is out there in the circuit courts and the time it would take to hear these? It does take to hear these.
The backlog of the general sessions caseload probably wouldn't deter these type hearings. You probably would end up in civil court, probably civil non-jury. I think the biggest issue time-wise is you take a county like Lee County or Williamsburg County where there's only civil court 8 times a year. You have to wait until that particular time, and that's a lot more court than, say, Jasper County has. So I think it's the availability of court.
The circuit court is probably not the best place for it. I think we agree on that. There ought to be something better.
I think we can agree with that as well.
Yes, Mr. Haygood?
You certainly raise a point, though, of its local availability as opposed to everybody being required to come to Columbia for an ethics commission decision or for the administrative law court. And thought occurs to me as we consider it, looking at alternatives, at least initially, for some informal decision process that, as you suggested, that might even allow telephone participation. I wonder if Mr. Harley would have any thoughts and reaction to that, if the initial round of appealing to some third party to provide guidance, if a telephone hearing or a telephone conference of some sort would be, do you think would be useful?
I think that would be helpful. I think a lot of what we're dealing with at any level and any of the entities that have to comply sometimes comes down to just understanding the law, and that could be mitigated by some training. And so if somebody, whether it's a phone call or some informal conference, can help smooth that process before it actually goes to court, that might be a really helpful.
You don't really have any third-party determination between the person who makes a request and the governmental agency, and they may have
Correct.
some difference of view. There's really no one other than a court to go to have any sort of third-party opinion on that.
That's right.
Okay, thank you.
Well, if that's an interesting point, because most people may know that judges in the federal court and the state court hear very important motions and make decisions all the time in conference calls over the telephone. It does not require people to travel. So that's
Maybe something we ought to consider is
that's a good idea.
got lots of public agencies in different corners of the state.
That's right.
That's a good point.
Anything else from Mr. Harley?
Do you know, Mr. Harley, if there's a record, if there's a requirement that it be recorded, which circuit court would be a court of record? There'd be somebody there typing, stenographer, taking everything down. Is that something that's a requirement, or?
I'm not sure, Mr. Jackson. That's a good question. It's something that we have to look into. It's a good question.
Any more questions for Mr. Harley?
I just have one. Mr. Harley, what do you consider a reasonable response time? I know the bill last year would take it from 15 working days to 15 calendar days. Tell us how you all feel about that.
Well, I think the main concern is that there will be times when a request could possibly take 2 weeks to respond or fulfill. I think last year's was 30 days to have it all completed. And current law says that you have 15 days to respond, and so we can evaluate what we need to do in order to complete the request, and then tell you what when we expect to have a reasonable time. I think it says a reasonable time for the request to be completed. And so, under current law, we think we have a good opportunity, a good window of figuring out what needs to be done and how we have to pull all the information together, and then the second part, letting you know when we'll get it to you, again, in a reasonable time. I think if you change from that, we want to make sure that you do keep in mind that there are times where it could take several weeks to fulfill a request when, and this is an actual case, I won't say where, but an actual situation where the administrator or the manager was required to give all of those emails to fulfill a request, to report a request, and it took several weeks to get it done. Of course, the reporter understood, because they knew what they were asking and knew the volume of work required. They understood that it was going to take a significant amount of time. Not everyone may not understand what goes into fulfilling a certain request. So all we're saying is that if you change that 15-day report notice, that keep in mind those things. And so I'm certain we could come up, based on what you want to do, we could probably come up with something that's a good response time and a reasonable time, again, to fulfill the request. But again, our folks had concern about what was introduced last year, so.
Be sure I have it right. You got the one who receives the request has 15 days to say whether you're going to respond or not and when, and then the response time is what they say they can handle.
What we encourage our folks to do is to, if you can respond with the information earlier than those 15 days, and we always train that way, that you do so. Only in the cases where you need that time to pull the records, assemble what's required, all those things, that you use that full 15 days. And then if you end up using those days, that you let them know a time certain that you will likely be able to respond or have the information ready for them.
Thank you, Mr. Rogers.
Well, you all do a great job in trying to educate your people. We'll reinforce that.
Any more questions for Mr. Harley? Mr. Harley, anything you left out?
No, sir. Thank
Okay.
you for the time. Thank you for your consideration.
We appreciate you being here. You're a big help. Thank you very much.
Thank you.
Next witness, Mr. Scott Price, Esquire, South Carolina School Boards Association. Mr. Price, welcome.
Thank you very much. General McMaster, General Medlock, ladies and gentlemen of the commission. My name is Scott Price, General Counsel with the South Carolina School Boards Association, and we represent the 81 elected and appointed school boards here in South Carolina. I will say that I was, before Dean Bierbauer's time, I was graduated from the College of Journalism, and I guess I have to say that Commissioner Rogers is probably very disappointed that acorn has fallen far from the tree in terms of where I am now with the School Boards Association. I want to thank you all for having me here this evening. I want to thank you for your service to this commission. It's a vitally important thing that you're wrestling with ethics reform as well as looking at the open records law. Probably not going to talk too much about the ethics reform aspect of this. Like Mr. Harley, we have 2 or 3 sessions a year in training that we provide either electronically or one-on-one or face-to-face with boards at workshops on ethics where we bring in the Ethics Commission staff to walk them through and answer questions related to ethics. So there's really not too much, I think, that we can add to that. And I'm not aware of specific issues related to school boards and school boards elections that have come up in recent years, at least through us, relating to the ethics. I will say that there's one area that I would encourage you all to look at in ethics reform in South Carolina, and it's got to do with the out-of-state or otherwise unreported and unknown funds that are now being routinely used with the intent to influence the outcome of our state and sometimes local elections. I mean, basically, I think public perception is that this type of campaign practice is unchecked and out of control in South Carolina, with there being really no reasonable way for the public to know who it is that's flooding the mailbox with these mailers during election time, or the TV ads, or the radio ads. The public just has no way of knowing. And the loopholes that allow secret groups and funded by unknown donors with unknown agendas wading into South Carolina races is something that I really hope that you all will take a hard look at as you work your way through this process. And I'd like to talk about the open records laws. And just like with the municipal association, we provide training 2 or 3 times a year to our membership on the Freedom of Information Act, or FOIA, in South Carolina. In the past, we had partnered with the Press Association on some training, and certainly would like to do that again. School boards are very aware of and supportive of the spirit and the legal requirements of the Freedom of Information Act, including the open records laws. In many instances where an issue arises relating to a particular request or production of documents, districts have to strike a balance between what's being requested and the FOIA's requirements, along with what federal requirements may apply, particularly in relation to student records. There are federal laws that strictly prohibit release of some student records, not all student records, but some student records. And so that's a balancing act that they have to do within the period of time they have under the law, as well as balancing impeding the privacy rights of their employees. As you all look into the issue of or evaluate recommendations relating to open records, I would ask that you, just as Mr. Harley had said, try to look at it from both sides of the issue itself, and guide yourself by what is reasonable for all parties that are involved. And I'll get specific in just a few minutes. But I think there needs to be some recognition too that, and again, just speaking for school districts, the FOIA can be abused as a tool to harass and even intimidate local officials. There are groups that routinely file voluminous and burdensome FOIA requests throughout the year, generally right at a time that districts are such as the holidays where the districts are thinly staffed or on shortened hours, when it's particularly burdensome for them to handle these requests. And the information that's being requested may or may not be public information. That's really not the issue here, but the issue is that the FOIA can be used as a tool to harass and intimidate public officials at an ultimate cost to the taxpayers if the issue winds up in court. And I think that underscores what was discussed earlier about why it is important for districts to be able to charge reasonable cost in association to doing research to fulfill some of these requests that come in. I know that recently there was a request that went statewide to every school district from the ACLU asking, and I've got copies of it, or a copy of it, and it was asking very specific information related to religious practices in schools, et cetera. And it was, I know one district's response was almost 170 pages in terms of what it had to turn over. And it was, I think it was a request that does underscore the need for school districts to be able to, if necessary, charge reasonable cost to gather these materials. On the response time, we talked a little bit about that previously, and I'd say that the School Board Association, school districts are comfortable with the current 15-day rule, as everybody calls it. I think that there probably can be some agreement on the need for a reasonable follow-up. In other words, the 15-day rule, as you pointed out, General McMaster, is in place for a government body to say, we're going to provide it or not. And then after that, they've got basically a reasonable amount of time to provide the information. And I think that there probably can be some limits that we should look at for that. I don't have anything particular to offer. I know the legislation proposal from this past session talked about a 30-day time limit, but that was from the original request, so it was actually a 15-day limit, and we felt like we had some concerns with that. We felt like that was too short. Calls for requests, I think this past year's legislation tied copying costs to the local market. I think that's fair and something that we were certainly supportive of. But I do want to underscore that it is important that school districts be able to charge a reasonable cost for searching documents, and particularly in the instances where the requests that they get are voluminous in nature or require research. Not every district has the resources that the one that I was just telling you about, which is over in Lexington County. They've got a staff, and they can certainly handle things like this, but not every district has the ability to dedicate people to a request that comes in. Enforcement, I think that we like the idea of opening the enforcement procedures to other entities, perhaps the ALJ or maybe even the Attorney General's office or the Ethics Commission, and maybe in conjunction with the ability to go to the local circuit court in instances, because it wouldn't necessarily be fair to require a local citizen in Bamberg to come to Columbia to try to work something out. So there might be some way that you can open up other avenues and still leave some local piece in there. We are supportive of that, looking at ways to make it better, easier, and less costly for the taxpayers in resolving these issues. Exemptions from public disclosure. In general, I believe that the current exceptions that exist in the FOIA are reasonable, and we do remind our folks in training that in almost all instances, these exemptions from disclosure are permissive and not a requirement. And I do want to make sure that you all understand that. I mean, we tell our folks that these exemptions that are in there, by and large, are permissive, and it's not something that they have to withhold. And finally, on this matter, I will go out on a limb and say that we do support looking at making the General Assembly follow the FOIA just like any other public body. I know that was an issue last year in relation to that bill, but I think that's something that's worthwhile looking at as long as you all are on the topic. On the scope of the definition of public body, we would support narrowing the definition of a public body as it currently we believe is too broad, and I think unintentionally brings in private organizations that may be supported in part by public funds, whether it's through dues or otherwise. And one of the things that I want to mention, since I have the honor of having the microphone, because this is one issue that's been around for a long time with us, or there's actually two issues. One of them that's not really related to what you all are dealing with, so I'll go ahead and mention the first one. The one that's not related is the reasons that are enunciated in the FOIA for allowing a public body to go into executive session. Our organization would support the ability for school boards to go into executive session to conduct assessments, self-assessment of the school board itself. We feel like that it's a venue that would be available that would allow them to have, I think, an open and honest discussion amongst themselves about how they're doing as school board members and how they feel their colleagues are doing as school board members. Again, that's not necessarily related to what you all are talking about, but it's been on our books for a long time, and so I want to just throw it out there. The other that I would mention would be the current requirement, and I think it was through the 1998 amendments relating to the providing materials, the exemption from providing materials except for materials related to the not fewer than three.
300
Yeah, okay, not fewer than 3 finalists for employee position or public employment position. That one's been kicked around a lot, and I think the Supreme Court settled the issue with the Spartanburg 7 case a few years back. But what I would point out is that when you look at the language, it applies to every employment position, and that's from maintenance staff all the way up to the superintendent. And now we all know that not every local community is interested in who the school board hires for the maintenance staff. But I think it's very broad in terms of how it applies to all employment positions. And if this may fall under where you all are, but I think that we would certainly support narrowing that to perhaps leadership positions or such as principals and coaches and superintendents. I know that's what everybody wants to know about. Again, I want to thank you all for taking on this task. I would encourage you to work through this with a sense of reasonableness for the parties that are involved, those who want the information and those who need to provide the information. And use of the FOIA for harassment and intimidation ultimately costs all of us as taxpayers. And at that, General McMaster and General Medlock, I'll be glad to answer any questions or.
Any questions for the gentleman?
Could I ask you, Mr. Harley mentioned that a clearer definition of cost, actual cost, would be helpful to him and his responsibilities. Is that something that you believe also would be helpful?
I think we could support that. I think that right now it's relatively silent, other than saying reasonable cost.
Would you like to see a formula that might be worked out with input from you, Mr. Harley, and others concerned?
I think that if you were to go down that road, and I'm sort of thinking off the top of my head, but if you were to look at some sort of an hourly rate perhaps that is tied to the staff person that has to provide the information or do the research, something along those lines, but I do think that, looking at a way to add some, narrow what that means is something that we'd be supportive of.
So a formula of some type could be somewhat helpful
Yes, sir.
to you. On the out-of-state funds, these committees that nobody likes, there are some U.S. constitutional restraints involved in trying to do anything about that. But what about disclosure? Have you considered the idea of requiring disclosure of the donors to those funds? And if so, would that help cure the problem as you see it?
I think it would go a long way towards curing the problem or the issue. I mean, obviously, some people don't think it's a problem, but I think that the perception of the general public is they want to know where is this stuff coming from and, who's behind this, because they're getting flooded with it. And probably everybody here at the table, in this room has experienced that. So I think that's, disclosure certainly would be helpful.
What you're referring to is the political action committees that receive money. There've been a lot of them in the last election, the national election, elections here in this state receive money, and it's not disclosed anywhere as to who's giving the money or how much, and there's no limit on it. Is that what you're referring to?
Yes, sir.
Where they run uncoordinated ads, they're not coordinated with the campaign. If those ads or the activities were coordinated with the campaign, then they'd be subject to the campaign finance laws that apply to candidates. But since they're uncoordinated, there's no limit. That's what you're talking about?
Yes, sir.
I've got another one. Oh, Mr. Price, you said that the public body definition is too broad. That is, of those who are subject to the Freedom of Information
Yes, sir.
Act?
Yes, sir.
Okay. Could you describe what you see as a little bit more as to what you see as the problem there is?
Well, I think if you look at what the definition says, and I believe it says that a public body is defined as a body, in essence, that is supported in whole or in part by public funds. And I know that the Weston case from several years ago, looked at this a little bit, and I think actually the Supreme Court may be wrestling with this issue as we speak. I don't think that it was intended to be so broad as to basically include, businesses that may have contracts with public bodies. They are technically within that definition a public body.
And under that definition, any business that had a contract to provide rugs for this building would be considered a public body, right?
I think if there's a newspaper that receives money from a government to run an ad on properties that are coming up for foreclosure or something, or for failure to pay taxes, one could make that argument.
General, if I could.
Yes, sir.
Clear that up a little bit.
Please.
If it's a quid pro quo, if you're buying a service like having a school re-roofed, that company doesn't fall under the Freedom of Information Act. It's only when it goes into their budget and they're supported in whole or in part by public funds. So people who contract with a public agency aren't subject to the FOIA.
Well, but
Their bills from the school board are,
But I think that, the discussion is that none of that is clear in the
it's
statute.
pretty clear. I don't know, but
Well, it seems like we got a disagreement going on.
I would refer to the Press Association, which I carry around and have dog-eared quite a good bit. It doesn't spell out or public body. Well,
It's on page 3.
I'm looking at it right now. I'm trying to find the one part that talks about the,
We don't want to put you on
supported
the
in
spot.
whole,
We
it's on, yeah, supported in whole or in part by public funds or expending public funds. And again, it doesn't say, doesn't delineate whether it's under, if it's under a quid pro quo, arm's length sort of transaction. And again, that's an issue that the court, I think, is wrestling with now. And, perhaps we could look at what other states do in terms of defining what exactly a public body is. Because I do think that it, if it's in question in here in the statute, then it's something that just needs to be, I think, cleared.
Mr. Rogers, you read it as money, tax money going into the budget, not
Right.
tax
If
money.
it's quid pro quo, they're doing a service, they're not subject to it. But if they put it in and pay their office supplies and their executive director, then they become public record. And that's the way it's interpreted widely around the state. I haven't seen any problems with that.
Well, the way you look at it, if you had an organization that got just a penny in taxpayer money, which I know that's an extreme example, but let's look, just a very small part of their budget, that would make them subject to the Freedom of Information Act.
The definition of in part would make them, I don't know that a penny would be, but the Museum of Art here in Columbia got several $100,000 in public tax dollars and then claimed it wasn't a public body. The courts decided it was, and they had to release their settlement of their firing of the executive director. But I think the public has an interest to know how their money is being spent. This is public money, that's my feeling, but
When was that, the case that you referred to?
I don't know. It's probably about 8 or 10 years ago. I can find out.
Mr. Price, do you know?
Is the Weston case?
No, the one where the museum here claimed it wasn't a public body because
Which, the
wouldn't release
Columbia
its records.
Museum, which museum?
Columbia Museum of Art. It was under the previous director. I'll find out and get something to you.
Okay. Oh, I think I had another one. I can't remember what it was. Does anybody have, if I remember, I'll call on you. Does anybody have any more questions? Mr. Rogers?
Mr. Price, I appreciate your comments. I had a couple of questions about the cost, and you're talking about reasonable cost. We had an instance in the past year where a school board in Richland District 5 wanted $500,000 to show their emails for the past year. How would you deal with that kind of logic that the public would have to pay $500,000 to see public records that belong to them?
Well, I mean, I don't know the circumstances that you're referring to. I mean, I could certainly give the opinion that $500,000 doesn't sound very reasonable, but I don't know what the extent of the request was either. Not that I'm saying $500,000 would ever be reasonable for a request to respond for FOIA, but if anything, that highlights the need for some sort of direction, I think, perhaps from this commission on what is considered reasonable cost.
Well, the abuse there came from the charging for the compilation of them, because they wanted even more to send them in electronic form. So that was really weird too. But also, how would your opinion? We had a school board member. We heard last meeting about a school board member in Cherokee County who arranged for her relatives and her significant other to be employed by the school district. If you want to start curtailing the release of records and salaries of officials to just the coaches and the superintendents, how would the public know about things like that happening at a school board?
I think that I think that the hiring of employees doesn't lend not every employee position lends itself to the type of process where you're gonna have finalists. I mean, someone comes in and, now if you're talking about an occurrence of nepotism, that's a different issue altogether.
But if there's no watchdog ability, how can you root out nepotism in this kind of thing?
And I think you and I are gonna disagree on this too, Mr. Rogers. I think that, the accountability lies with the board. One board member can't hire somebody. That entire board has to hire somebody. And that's the accountability for hiring family members of a school board member, which is not, again, that's, I'm not saying whether that, I don't know the circumstances, I'm not saying whether that's right or wrong, but I think the ultimate accountability lies with that elected board.
We had a case in Charleston last year where a school board hired an attorney to do its superintendent evaluation and then claimed it was attorney-client privilege and secret, so the public was totally left out of that. How would you deal, you're talking about self-assessment and secret. How would you keep that from happening?
Well, I mean, the Supreme Court looked at that issue.
Yeah,
And the
and-
Supreme Court the Supreme Court didn't say that the board had done anything wrong in that case. And you and I have talked about this.
But they did send it back for retrial.
They sent it back for further information. I mean, because the fact that the attorney-client privilege exemption exists in the FOIA, it is there. And in this case, I believe the case involved a situation where the board felt that it was necessary to include their attorney in the evaluation process. And again, the Supreme Court didn't say that was wrong. Now, I'll admit, they expressed skepticism in relation to that being a practice, but the facts just weren't there in that case to state whether it was right or wrong, so the Supreme Court didn't give an opinion on that. I think that getting back to what you're saying, that's a different issue. That was an evaluation of the superintendent,
Right.
the highest, the executive officer of the
right,
district.
He's making a lot of money, and the public should be, do you think they should be entitled to see the evaluation of this highly paid employee, or it should be done in secret?
I think that they should be, they do, and all that, in that instance, I believe the evaluation of the superintendent was issued. There were specifics related to the process that I think the newspaper was trying to get hold of.
It was a
Personal notes.
summary of the
Personal
evaluation,
notes and
so.
summaries, and that, that's not the final evaluation. That's just the process that goes into the evaluation. And what I'm talking about again, I apologize, because it doesn't have, I just took the opportunity, because I was here to talk about, we would like the ability for school boards to assess themselves in executive sessions. I mean, it's just something that we feel that would lead to a stronger governance, a better board. Now, but that doesn't have anything to do with what you're talking about on evaluating the superintendent.
Need a moment to think of some more, Mr. Rogers?
No, I'm gonna leave him alone.
Well, you made me think of some. Mr. Price, if we had a quick way to resolve disputes, a quick and convenient and probably informal way, as we've discussed with Mr. Haygood's question a few minutes ago, do you think a body of law or body of opinion could develop that would lend to guidance in these questions rather than trying to delineate a strict, Mr. Medlock mentioned a formula, which would be a perfectly good idea. But are there, would the presence of a quick way to resolve questions over how much time is allowed, how much it should cost, is this or that subject to the Freedom of Information Act, and where you'd have a written opinion on that, would that be helpful in guiding cases in the future?
Might depend, it depends on what the opinion says, I guess. But I do think that, to get back to my original statement, it may or may not be helpful, I think. But I do think that anything that simplifies the process for all parties involved, again, looking at the substantial costs that public bodies and the members of the public or incur in pursuing something through the court, I think everybody would benefit by looking at a simplified version.
I have one more. We've talked about an organization that receives money, tax money, for any amount is subject to the act. What does the act say, or what's the case law say about if anything, about an organization that maybe does not receive tax money, that is a direct appropriation, but is involved in the retirement system or some other state-run thing like that, service?
I'm not aware of any case law that gets to that specific point about involvement in the retirement system, et cetera. I think that a direct appropriation is a different matter, and it's not a issue that has been addressed very often by the court. But I think a direct appropriation is a little clearer, although I'm not even sure that's clarified in the definition under the FOIA.
Any more, Dean Beerbauer? Any more questions for Mr. Price?
Mr. Chairman, I just had kind of one thought in response to Mr. Price and Mr. Harley's words here tonight and perhaps I just would throw this out as a reaction, perhaps form of a question to you. In trying to sharpen the pencil on determining reasonable cost and reasonable time frame for response, it just seems to me that things like the form of the record, as Mr. Harley had suggested, or perhaps even the location of the record, as to whether it's on-site or whether it's off-site, perhaps even the genuine need of the requester for time frame, some sort of representation of when the document is needed by for whatever purpose. Are those the types of things that you think are practical factors and that perhaps could be useful in delineating level of effort and the time frame required to respond to some of these things?
I think so. I think, one of the things that was in the bill last year, I believe, set an extra amount of time for documents that were more than 2 years old or something like that in terms of having to provide it. So I think that, yes, I would say that the location of the document, the form of the document. Somebody had asked earlier about whether some cities still use paper, and I had to smile at that because there are a lot of districts that they may have a website and they're posting all their expenses on the website like the law requires, but that may be as sophisticated as they are in terms of their document retention, and would have to go back to storage to dig something out and may not have it electronically. So I think those would be valid factors to look at.
Thank you.
Do you have any guidelines now, Mr. Price, that you disseminate to the boards in terms of assessing cost?
No, sir, we don't. And again, it's a lot of it's got to do with the actual size of the request, as much as anything. If it's going to take a designated staffer a certain amount of time to go back and do research and pull documents together to fulfill the request, but we don't give our membership guidance on what a reasonable cost might be.
Any more questions from any member of the commission? Mr. Price, we appreciate your time. You've been very helpful.
Thank you all
Appreciate
very
being
much for
here.
having me.
Thank you. The next witness is Jared Bruder from the South Carolina Law Enforcement Officers Association. Welcome, Mr. Bruder. We're glad
you.
to have you and look forward to hearing from you.
Thank you, I
for coming.
appreciate it. General McMaster, General Medlock, thank you for having me, other commission members. I'd like to start off by saying that I did not know it until I got here, but I think that Mr. Harley had filed a FOIA request at my office and got my talking points, because it's several of the same things. But anyways, I am Jared Bruder. I'm the Executive Director of the South Carolina Law Enforcement Officers Association. I represent about 8,000 law enforcement officers from across the state. About 160 departments are members and help in that process there. Like I said, many of the issues that Mr. Harley brought up about the expense of going through this, both expense in actually reproducing documents or the expense in having staffers dedicated to this cause, is a major concern of the law enforcement communities. But probably the foremost concern is the exemption that is currently in the law now that allows for law enforcement to be exempt from FOIA requests for basically pending investigations. I think in the legislation that was proposed last year or earlier this year, there was a movement to try to go around that. Maybe not intentionally, but some of the collateral damage from that law would be that we would be subject to having to submit those documents. And again, we just want to make sure that protection is there to preserve the integrity of the investigation. A lot of times there are different techniques, there's different things that happen in the course of an investigation that we feel like we need to keep private until that course has been adjudicated through the courts. And again, we have no problem whatsoever with sharing information, but we want to do that at the appropriate time after things have been run their course through the courts. Again, on the issue that Mr. Harley had brought up about the expense and the individuals being dedicated to this cause, I would just remind everyone on the commission that most police departments in South Carolina have 15 men or less. 15 men or less, and that's running everything that a police department does. In most cases, we're struggling to get the appropriate number of people to do traffic, much less answer FOIA requests. But it's something that we all have to do, and we all have to take the time to get on that and support that cause. Again, with that being said, it's a daunting task sometimes for these small departments who have very few people or are a one-man department, because we do have several of those throughout the state as well. But again, Mr. Haygood's comments about it sounds like the direction you're heading or thinking about some type of formula or figuring out some type of way to figure out a uniform way or an easier way to do away with these discrepancies. I think our association would support that, and law enforcement in general would support that, so that we can get out there and do the things that we've been tasked to do by the law. Again, our biggest concern is that exemption, and hope that if y'all are moving towards making changes, that you would keep that exemption for law enforcement for the integrity of the investigations that we're going through. Other than that, I don't really have any additional comments. Just kind of thank you all for the opportunity to come out and speak and let our voice be heard on this issue.
We appreciate you being here. Any questions for Mr. Bruder?
I would like to ask your statement about most departments having 15 men or less.
Yes, sir.
I certainly assumed that you really meant to say 15 men or women.
That's correct. By men, I mean officers. Yes. So.
Could you give us an example of one of your investigations that has been in the limelight where you have felt pressed, too pressed to reveal data?
I'm not going to say that I know this firsthand, but looking at the news and seeing the different things that are going on, the different things that have happened with some of the murder investigations that have been going on in the city of Columbia and out in the Irma area, different things that have gone on with that. There are Freedom of Information Acts that have been filed with those departments trying to get that information, and it's just too early in the case to do that. And to be fair, a lot of people think that that a case has run its course once the person has been arrested. And that's not the case at all. It has to completely run its course through the courts before it's able to be released to the public. And so, whether or not they're trying to get information about a suspect or this or that, there's many times that it's just not the right time. It's not that we're trying to withhold information, it's not the right time to put that information out to the public.
Does the request typically ask for the entire file?
It can vary. It can vary. Somebody asked about a typical request earlier about something else like that. Sometimes they're asking for so many things that it's boxes of paperwork that have to be transpired out there to the individual requesting the information. One specific, and I talked with a person involved with doing these things at one of the other agencies. They said that they had gotten a phone call just last Friday asking for an autopsy report for a murder investigation in 1983. Out of the entire, massive file, they wanted one single report, and so it kind of varies with the different requests that come in.
I
Sometimes
presume that case was over by that time.
I would hope so.
It's probably easy to give them the whole file and to find one document.
That's right.
Let them find it.
That's
But
right.
isn't there some reason not to turn over all those, or the privacy concerns, or?
There certainly are, with the amount of information that is collected in some of the investigations and the sensitivity of some of the information collected in those investigations. Sometimes you'll have social security numbers, bank account information, other types of information that's included in those types of files. And again, it falls back on the agency to redact that information and make sure that the information that is allowed out is the appropriate information per law, and that we are being sensitive to protecting that individual's.
Mr. Brewer, are you seeking a change in the law?
I don't know, the law that we have right now is a fairly good law. I think that there would be a need to look at a couple of things, like we've mentioned the 15-day rule and those types of things. Sometimes, like the 1983 autopsy report, that's not an easy thing to come up with in that time frame, and it can be, there are certain cases that push you out beyond that. And again, it's, I don't know that we have to have changes necessarily in the law, but there may be a few things that could be improved. So,
Mr. Ruger, do you consider the exemption to be blanket in the sense that you're not required to respond in any way while there's an investigation?
I don't think so. I mean, I think the statute kind of defines what is and what is not allowable in that exemption. And so, I mean, there are certain things that we can be exempt from and other things that we can't be. And I'd have to pull it up and read it to be able to tell you for sure, but I don't feel like it's a blanket, and I don't feel like it's an abuse of power.
And you mentioned the point that you have the capacity to redact the file.
Right,
So social security numbers are not an issue per se.
right.
So it's a question of whether there's a middle ground between what might be asked and what you really do have the capacity to deliver. Is that not correct?
That's correct. And I would add that in most circumstances, we try to find that middle ground, that if there's a middle ground to be found, that we're going to try to work with the individual who's asking for that information and provide that to the point that we can.
Are there examples where you've been required to reveal information that was detrimental to the investigation?
I don't know that I can think of one right now, because most of the time we've been trained in this exemption and we've been able to fall under this exemption and be protected from that. So I don't know that I could name one for you right now, but I'm sure that there may be one out there.
Well, it takes so long to resolve it, to force you to do it. By that time, the investigation's probably over. Mr. Brewer?
Does your membership include law enforcement on college campuses?
Some of them, yes, sir.
Okay.
It's completely optional as whether or not they want to do them.
Mr. Hagan?
Mr. Chairman, a little bit of follow-up on Chairman Medlock's questions. Just to be clear, your remarks tonight are out of concern to ensure that the current exemption remains the same. You're not seeking a change.
That's correct.
You just are very concerned about.
We want to make
Could
sure
be
that that's there.
changed.
That's right.
And as I've always understood that exemption, I guess my experience in prosecution, as I know others have had, is that the intent, the thought behind that is to protect things like investigative techniques, perhaps identity of witnesses or confidential informants, perhaps prosecution strategies, things of that nature that could jeopardize the investigation and the prosecution before a court resolution. Are those the
That's
kinds of
correct.
things that you're concerned about?
That's correct, sir. We, it was our understanding, and I may not be 100% correct on this, but it was our understanding that the bill that was brought forth last year looked to do away with some of that, and so we want to make sure that that exemption is intact if changes are made to the current statute.
Thank you.
Mr. Jackson, anything to add?
It is, as in my career as a prosecutor, we were always able to work out those issues with local press. We always were. That exemption worked well, and I can't think of a single instance in my career that it didn't work out.
You didn't have to go, you weren't taken to court?
No, sir. Very fair on both sides.
Any more questions for Mr. Bruder? Mr. Bruder, anything else to say?
Sir, I appreciate your time.
We so appreciate you being here, and
Thank
we
you.
thank you very much.
Yes, sir.
We have another witness. Before we call them, since Mr. Price and Mr. Harley are still here, I'd like to ask you all a question that I meant to ask earlier. You can keep your seat. Is there, the lobbyist rules, the rules about lobbying and registration do not apply to school boards and county councils, do they? They do?
I would think they do, General McMaster. In fact, if you've got a situation where a school board member is spending a specific amount of time in front of the legislature, I mean, that might require that board member file as a lobbyist.
How about the lobbyists appearing before the school board or before the county council? Is that an area that we've explored at all?
A lobbyist appearing before, somebody who lobbies
Yes.
school boards and
Just like they lobby the legislature, they might lobby a school board, they might lobby a county council.
I don't know if I've ever met anybody that lobbies school boards.
I don't know if they,
Except for parents. Sorry, are you asking like these people are trying to influence school board decisions or policies
As
on
paid lobbyists.
homeschooling or whatever, and they're not registered as lobbyists? Is that your
right, well,
question?
as paid lobbyists.
Yeah, I don't know, that's a good question.
But I would tell you, I
They
think the
should be.
statute does provide for, I mean, if you've got somebody that's out there and maybe they're a vendor or something and they spend a lot of time, trying to work school boards on a particular issue, I mean, arguably, they would need to register as a lobbyist to lobby local school boards. I think you could make that argument.
Mr. Hagan.
I may be mistaken, I'm just going from memory here, but I thought that the lobbying rules applied only to trying to influence the vote at the state level, General Assembly or governor at the state level, but not at a political subdivision level.
That's my understanding,
Yeah.
but I'm subject to error.
And I also thought that the first part of your question with regards to whether a school board official who might be coming to Columbia or any other governmental agency might send somebody to Columbia to try to influence outcome of legislation, whether they should be registered as a lobbyist principal. I think that's addressed with regard to whether that's that person's full-time duties or whether they're paid just for that or whether it's a collateral duty if a executive director or a board member comes up and puts in that extra time to speak on a bill that happens to be coming up affecting them, then I think that's covered as non-lobbying, but as part of the regular duties. But I'm just going from memory here.
And I
Yes,
think-
sir.
I think the statute also, in addition, makes recognition of the fact that there are school officials, teachers, school board members who might have particular expertise in the education arena, and therefore would be able to express those opinions on issues to legislators without having to register.
Okay. All right, thank you. Mr. Gardner Gore?
Yes,
Come forward, please, sir. We're glad to have you, Mr. Gore,
thank you.
a private citizen.
Thank you.
Welcome.
Mr. Pedlock and Mr. Master, ladies and gentlemen. I appreciate the opportunity to talk with you. I hadn't decided yet whether I'm crazy or brave. It might be a little bit of both, you know, as a private citizen coming before a group like this, but I feel there's a time when you just have to talk. And I think we've reached that point in Sumter County. I'm chairman of the Committee for Responsible Government in Sumter County. You can call us a watchdog group. I'd prefer to be called a group of intelligent people that simply want good government. And we're made up of Republicans and Democrats. We have blacks, whites, and Hispanics in our group. And we all agree to agree without being disagreeable. And that has worked so far. If I could, let me just ask the ones that's members of our committee to stand just briefly, if you would, where they could see who you are.
Welcome. Appreciate you coming. Thank you.
And Mr. Kelly Jackson over here, he and I go to church together, and I've known Kelly for a good while. And Kelly knows a lot about what I'm talking about. And we've had sort of a circus in Sumter now for about 2 years. As chairman of the Sumter County Committee, I'm going to read a statement here, Salter, and I'm going to elaborate some, but I'm going to leave a copy with you and some information for you. As chairman of the Sumter County Committee for Responsible Government, I would like to thank Governor Haley, Attorney General Alan Wilson, and your committee for the job being done. Our group has documented corruption in Sumter County, which we have been assured will be investigated. This action is long overdue. All laws should apply to all levels of government, including county government. And there is a lot of corruption that starts at the county level. And there's really no laws or means or anything to bring it out. Audits should be randomly made to enforce transparency, compliance of bidding on construction projects, advertising county management positions, proper spending of state and federal grants and funds, and complying fair taxation, including property assessments. Some counties want some relief from state control. This, I hope, will never happen. We need more control than what they have now, unfortunately. And that may be because there's just not a way of enforcing laws and people reporting things, being scared to talk, or what might happen to them. Because of my activities with the Committee for Responsible Government, I am presently being punished by the county, who are raising my taxes and refusing to give me due process of appeal. Now, I know everybody's fussing about their taxes going up, but at least to have the opportunity to appeal them, and I'm not even granted that. The tax assessor has told me not to expect him to be nice or friendly, and asked me to not come back into his office without an appointment. Local politicians cannot afford to get involved, and I think you all know that. If I've got some good friends, Merle Smith and others in Sumter, but if they were to take a position on this, or they were to try to get some action taken, I think you can imagine how it would affect them politically. So it leaves it to somebody like myself or private citizen on the county level to expose anything. There must be a new way to handle investigations on a county level, and citizens must be protected from retaliation. I'd like to comment too about this freedom of information, which you've been talking about. Now, this committee, I am confident that we have documented sufficient information that we got a solid case of corruption in Sumter County, but it's yet to be investigated. I've been assured that it will be investigated. Now, it's taken us 2 years of investigation in this matter. And we have used the Freedom of Information Act as been one of our sources of information. Now, first of all, Sumter County government has a stated policy that they will not answer one question, they will not comment, period, on any comments that anyone else has. You're allowed 3 minutes to comment. It was 2 minutes until this group got involved, and that's the only thing that we've accomplished is getting them to raise it from 2 minutes to 3 minutes. But you can, in that 3 minutes, you can go in there and say what you want to, but they have no expression, no sign of approval or disapproval of what you say. And that's the end of it. And information that we should have, and right now we're having to pay for that information. I think they thought that they would keep it, you know, without us paying for it, but we're paying for it. As a matter of fact, I sent them a check today for about $55.69, I think, to be exact on it. And we've tried to get some answers from them, things that I knew the answers to. I don't ask a question from them unless I already know what the answer is. And Kelly here can tell you I've written letters to the editor and raised pretty serious issues, and they still refuse to talk about it. The only thing that Gene Baton would ever respond to is anything I said is, he's a racist. Anybody that disagrees with the chairman of our county council is a racist. Well, now, we've got all races in our group. And unfortunately, the people that we're accusing the most of criminal things, in our opinion, are white Republicans. And I'm one myself. I've always been a Republican, but I also believe in right and wrong. And it doesn't matter to me whether someone is a Republican, a Democrat, black or white, Hispanic or what. Wrong is wrong. And that's one thing that this group and myself, we've all agreed upon, is that it's going to be nonpartisan. None of those things are coming into it, and it's worked real well. Now, to begin with, we had a little bumpy road. We had 2 or 3 that wanted to sort of sabotage us, but we took care of that. So we're operating pretty good right now, and I think things are going real well. And this is sort of a bad time to bring this up when you're looking at these new laws, but I felt like while you were looking at them, we had to come forward and say something. And there would be nothing that I would like better than to sit down behind closed doors and show you what we've got. But I don't think it's anything that ought to be made public at this time. I wouldn't want to say anything that would jeopardize an investigation, which at this point appears to include the Attorney General's office and the Labor and Licensing Board. So it's pretty involved and pretty serious in my opinion. And that's about all I have, unless you have a question.
Questions for Mr. Gore?
Beg your pardon?
I say, are there any questions for you? No questions? Yes, sir.
And correct,
Dean Bill
the
Bauer?
Attorney General's office is
The Attorney
investigating your
General's office
allegations?
has it. It was sent to the Attorney General's office by the local sheriff's department. It's in his hands. I have talked to some FBI agents, and the head of the Labor and Licensing Board and the investigator has contacted me. And they've gotten a lot of information, but they hadn't really got into the investigation at this point.
Are there specific steps that you would like this commission to look at? I mean, we understand you feel aggrieved in the situation.
Well, the main thing, I think, is to have it clear where any law passed along with nepotism, corruption, or whatever, and I commend the governor and Alan Wilson for, I think they should have brought this about and probably was behind organizing this group. It's way over time that we had this, and it's time that people in a county could complain about something and be heard. And now, in other words, and of course, see, we can't even ask a question of the Attorney General as individuals, and I understand that. He couldn't have everybody calling his office every day wanting to know some question about some of these things that come up as to what the county council can do or cannot do. But there's just got to be a way of doing these things and passing these laws. And I think a good thing would be that in this statement I had here, if there, the state should hold the county accountable for any state grants or federal grants that's run through the county, see to it they're spent properly, and that the people have real knowledge of what is going on. And it just needs to be, and I know there's been some things on a state level, as I understand, that a private citizen could report, and they didn't have to worry about, what somebody was gonna do to them. But it's not that way down in the county. There's no, as far as I'm concerned, there's no system. You've got laws that says that they can do this or that and the other, but who's gonna question it? Who's gonna enforce it? Nobody.
Any more questions? Dean Beerbauer? Ms. Key?
In your current, the current FOIA Act, have you had any issues getting information from the county? Have you run into that?
We've had some things that they claimed that they couldn't give. Now, one thing that we asked, I don't think this will be saying anything out of line, but where are you bringing that up? We had requested an appraisal from the U.S. Agricultural Department here in Columbia that we felt like, in our opinion, was fraudulently used in this. And that's what the Labor and Licensing Board is going to be investigating. And of course, the appraisal was obtained and paid for by the recipient of the money. I should tell you a little something to have a question. And this gentleman with the U.S. Department of Agriculture refused to give it to us based on the reason that it had been paid for by the person that obtained the funds, and it was his property, and therefore they could not give it to us. But I would take the opinion that once it is used for paying out public funds, it is at that point public funds. That's not, I'm no lawyer, but I've had a lot of experience with lawyers. And of course, our attorney that represents us, he is part of our group, is Ken Young in Sumter. I'm sure some of you know him. I think he's a very good attorney. He's stood by us and advised us, and we do most of the work, whatever, but we're the more active ones, and I try to keep him advising me to keep me straight and out of trouble. And he said, well, we'll just file a federal suit against him. I said, no. I said, yeah, I know enough, because I've been a licensed contractor. I'm a real estate broker now, and I've been an appraiser. And so I told him, I said, just wait, because I knew we could get it from the Labor and Licensing Board, and it's going to look worse on them to have to get it that way than then just come forward with it. And we've had some problems with the county not wanting to give us information. We've even, as Kelly knows, gone to the paper with things that I knew the answers and asked them, and like I say, they would not give us any answer. They have refused to give any answers to anybody, and I think the public they're entitled to that. They're entitled to know how their money is being spent. And if they know of $1 million that was spent somewhere that's very questionable, they're entitled to know an explanation of it. We hadn't been able to get all those answers, and it does involve a lot of money.
Any more, Ms. Key?
No.
Any more questions for this gentleman? Anything else to say?
That's all.
Well, we appreciate you
Thank you
coming.
for listening.
Thank you very much, sir, Mr. Gore.
Thank you.
Is there anyone else who would like to speak to the commission? In that case, is there anything that any of the commissioners like to make a statement about anything? In that case, we call on our counsel for some information.
Okay, just a few things. I gave y'all prior to the hearing a number of documents that had been submitted to the commission, and I wanted to give to you. The South Carolina Association of School Administrators, the executive director, Molly Spearman, sent a letter to the commission for consideration. So her written comments are in there, and I wanted to make sure you received those. I provided you some information from Professor Simpkins regarding some issues that have been raised at prior hearing, and I wanted y'all to have the benefit of those. The League of Women Voters has presented some written recommendations. They will be commenting on those tomorrow as well. I wanted y'all to have the benefit of that as well. We also been provided some information from and I know I'm going to mispronounce his name, Professor Higgard, I believe is how you pronounce it, from MUSC regarding some issues with the ethics laws and how it has impacted public officials and innovation. Again, he wanted to make sure all the commission members received those, and you have the benefit of reviewing those. Tomorrow, I'd like to discuss real quickly, tomorrow morning's here. We're starting at 9 o'clock. I sent everybody updated email regarding 9 o'clock, and I'm going to request that everybody get here at 10 till 9. And this is, we publicly disseminated this. Governor Haley's going to be the first speaker tomorrow morning at 9 o'clock. She has a very tight schedule, and she was, we were able to get her schedule changed a little bit so she could come present to the commission. So I'm going to ask everybody to be here a little early so we can kick off right at 9 o'clock. And that's going to be followed by the Attorney General. And then members of their staff will be available to answer questions after the governor and the Attorney General speak, because they've got pretty tight schedules. So, and what I've got, how I've broken it up is we're going to hear from folks till about noon, and then from noon to about 1 or 1:30, take a lunch break, and then we've got additional folks after that to speak as well. Folks from.
Can you tell us who those are?
They are,
Do you
yes,
have a
yes,
list?
sir, yes, sir, I do. So it'll be the governor, the attorney general.
And will they be submitting written statements as well?
I believe it's just gonna be, initially, we're probably looking at, just a testimonial type statement. If there's any follow-up, I'm sure we could ask and get that in general. And then members of their staff will be available to provide comments. We can ask questions of those folks. The State Ethics Commission, I've talked with Kathy Hazelwood. Either her or Mr. Hayden will be here tomorrow morning to present. Ms. Landis from the Policy Council, Ashley Landis, will be here. Then we're going to take our lunch break. I think that'll probably get us to the noon hour. Mr. Krangle from Common Cause has been kind enough to
He's here now?
come and talk to us tomorrow. I don't want him to say anything yet because I need him tomorrow for my schedule tomorrow. Ms. Lynn Teague from the League of Women Voters is going to be here to speak with us. The South Carolina Association of Counties, I don't know exactly, I believe it's Mr. Crone is going to be here to talk with us. Brett Bursey from the South Carolina Progressive Network is going to be here. I believe if he may be a counterbalance to South Carolina Policy Council if you wanted to do a comparison and contrast, if you will. And then Ms. Patricia O'Connor, who is a former, she used to be in charge, and I'll defer to Mr. Rogers on this. I believe she used to be in charge of the FOIA Committee for the South Carolina Press Association. Is that correct?
Yes, and she's editor of the Sun News in Myrtle Beach for many years.
So she will be here in the afternoon to speak with us as well. That's what I have. We've got a pretty full schedule tomorrow.
That's so far.
That's so far. And I mean, I don't think we've got any additional ones. I'm still waiting to hear back from some folks, but I'll just,
Okay.
if we hear from them. So tomorrow, I'm asking everybody, I'm gonna put my military hat on here for a second, and
We heard you the first time.
Yes, sir.
When we conclude tomorrow afternoon, does that bring to a close testimony from people on the outside coming to?
Unless we decide to have another one,
That's correct.
which we can do if we want to. Then we go into the work sessions, I believe. And that's what the schedule is so far, Mr. Harold.
But we can certainly continue, and I've received written comments and written recommendations from organizations, and again, whenever I'm contacted, I invite them to submit those to the full commission, and as we get those, I push those out to y'all. I know there's some information I need to push out to folks that we received from the state of Iowa that Mr. Rogers was able to get from the folks at the Press Association in Iowa, I believe. that I think's going to be helpful as well. So that's where we are for tomorrow. Somebody had asked me about parking for tomorrow, and this is an issue that's
Yeah, that's a
brought
good
up.
question.
I have seven parking spaces. If y'all want to do a tug of war over it, I've got 7 parking spaces in the parking garage that I can apportion out. If people need to park, you can park in my firm's parking garage, and I will make sure that, and then you could walk from our parking garage, from our office over on Main Street over here to this building, and I'll take care of addressing the parking situation if you want to park there. So, if
See
y'all want
you
to just
after
let
the
me
meeting.
know afterwards, let me know.
Okay. Any questions for our lawyer? All right. Any further business? General Medlock, may we conclude?
I thought all the presentations tonight were excellent. And Mr. Gore, is Mr. Gore still here? If you or your attorney want to make some specific recommendations as to any changes in the state ethics law that could be helpful to Sumter County, we'll be happy to have those.
I'll talk to him and check with Kelly over here, get a news and real well, and we'll talk about it.
You know where the Bowes Crossroads is?
Yes, sir.
That's my stomping ground.
That's a good part of the county.
Thank you.
Well, as we close, I'd like to remind everyone here, as well as the members of the commission, that we're seeking information and ideas from any source, and we're encouraging everybody to feel free to call us, to write us, to better hurry though, because our report's due on January the 28th. And we're not standing on formality, we're looking for ideas from anyone who has some. Yes, sir, Mr. Gold.
Could I make one statement I forgot to say?
Yes, sir.
The young lady's going to pass out some statement here on what I have, and a couple places there, the secretary referred to it to be progress in the committee for responsible government responsibility.
There being no further business, we will stand adjourned until tomorrow morning at 9 o'clock. Thank you.